7, I made this first question and I made it so difficult that I got it wrong myself. So it was unfortunately for that reason wrong on the answer key. And I'm going to go over it and tell you why. So this says, which if any of the following are true concerning a preliminary injunction? And the first one says, may be granted ex parte. So we all know that that's not true, it has to be on notice. The second one says, it must appear that immediate irreparable injury, that's about a TRO. So most of us probably knew that was false. 3, unless the court orders otherwise, a motion for a preliminary injunction along with the papers upon which it's based and a notice of hearing for the preliminary injunction shall be personally served in the same manner as a summons. That's also wrong because it's the language for a TRO. And the last one, which is what I got wrong, says prior to the granting of a preliminary injunction, the court may require the plaintiff to give an undertaking in an amount to be fixed by the court. Now this is wrong because it's plaintiff shall give an undertaking. If you can avoid mixing this up with the thing in Article 62, both of them are a shall give an undertaking by the plaintiff. And the one in Article 62 even has a monetary minimum on it. So the answer should have been E, none of the above, because none of those are correct. Number 2, 6314. This is another difficult question. So this says, 1, a motion for this relief may be made with or without notice. So that is false, so I would put a little F there. In general, the court may require the moving party to post an undertaking. Well, that's true, so leave it alone. 3, an order granted without notice, vacating or modifying a preliminary injunction shall be effective when, yada yada, and this is obviously false because it says without notice. So that's another little F next to that one. 4, a defendant enjoined by a preliminary injunction may move at any time to vacate or modify it. And that's true. So the answer was D because it was asking for which is false. 6212, on a motion for an order of attachment or to confirm an order of attachment, the plaintiff must show 1, that a cause of action exists, 2, that one or more grounds for attachment provided in 6201 exist, 3, that the amount demanded from defendant exceeds all counterclaims known to plaintiff, and 4, that it is probable that plaintiff will succeed on the merits. They're all true. 7003, if a judge improperly refuses to grant a writ of habeas corpus, he forfeits to the person detained $1,000. None of the others are true. 7006, if a person whom the writ of habeas corpus is served refuses or neglects to obey it without showing sufficient cause, the court before whom the writ is returnable, upon proof of service, shall forthwith issue a warrant of attachment against him, and it's got to be directed to the sheriff in any county in which such person is found, requiring him to be brought before the court, and then he may be committed to the county jail until he complies with the order. So that's why D was wrong, because it says shall order him committed to the county jail, and the statute doesn't say anything about holding the person in contempt. 7510, the court shall confirm an arbitration award on application of a party made within 1 year after its delivery to him, unless the award is vacated or modified upon a ground in 7511. I think that seems like an awfully long time to actually turn it in, but that's what it is.
It's not Mary, it's not turning it in.
Oh.
It's how long the court has to confirm it.
Oh, thank you for clearing that up for me, so it could sit on the judge's desk for a year. Okay.
Well, then it's not enough time.
Then it's not enough time. With regard to an appeal from an Article 70 proceeding, an appeal may be taken from, and answer is C because it's both A and B. It's a judgment made upon the return of such a writ or in order to show cause, or a judgment refusing to grant a writ of habeas corpus. And it actually is also, this isn't in the choices, but it also can be appealed a judgment refusing to grant the order to show cause. 7803, which of the following questions may be raised? And I think this is all of the questions that may be raised, whether a body or officer failed to perform a duty, whether a determination was made in violation of lawful procedure, whether a determination was arbitrary and capricious, whether a body or officer is proceeding in excess of jurisdiction, and whether a determination made as a result of a hearing held at which evidence was taken was supported by substantial evidence. I think that was all of them. 7804, unless the court grants an order to show cause, an Article 78 proceeding must be commenced by filing a notice of petition and serving them on any adverse party at least 20 days before the time at which the petition is noticed to be heard. So the time rules in this is 20, 5, and 1. And this also has to be a verified petition. For an Article 78, you need a verified petition and a verified answer. Question 9, 7804, and this is also in 506B. Article 78 proceedings may generally be brought in. Now this is my dad's question. It's a very annoying question because there's like a but. But basically the answer was Supreme Court, okay, in the county, in the judicial district, and then there's a list of things, but there's a whole bunch of other things if you look at 506, which tells you if you're suing like the regents of the state of New York, then you gotta do it in Albany. So just maybe review 506. It's hard to remember that stuff. 7804, the appellate division doesn't want the case. So this is saying that the justice in the Supreme Court has to try to do everything he possibly can to get rid of the case before kicking it to the appellate division. And if he can't, because he could not make the determination if the hearing was supported by substantial evidence, he's supposed to make an order transferring the proceeding to the appellate division. 7009, when a writ of habeas corpus is ordered to produce a person in detention by virtue of a mandate, the court shall not adjudicate the issues in the proceeding unless written notice of the time and place of the hearing has been served either personally 8 days prior or in any manner or time as court may order. So what's interesting, I think, about this one is that it's in kind of the old language. Now, if you look at like the statutes they've updated, it will always say date, time, and place. This one just says time and place. 7804 and 506. Here's one of the exceptions to where you bring in Article 78, because if you're bringing it against the justice of the Supreme Court, you're obviously not going to bring it in front of his colleagues. So you have to bring that in the appellate division, in the judicial district, where the action ... originated, his tribal. 7804, this is the time rules, I already did that. So skip question 13, go to 14. 7805, if an Article 78 proceedings seeks a stay of an order or judgment granted by the appellate division, such a stay may only be granted by the Court of Appeals or the appellate division. 7005, a writ of habeas corpus may be served on any day. 7002, which, if any, may never entertain a writ for habeas corpus. So that would be for the Court of Claims judge, because there are circumstances where the county court judge can do it. 7007, a court authorized to issue a writ of habeas corpus shall also issue a warrant of attachment for the person detained upon satisfactory proof that a person is wrongfully detained and will be removed from the state or suffer irreparable injury before he can be relieved by habeas corpus. So this question was really just looking for the warrant of attachment, but it has other information in it. It tells you that if this is going to happen, they have to show, one, the person is wrongfully detained, and then either he's going to be removed from the state or suffer irreparable injury. Does anyone care if I skip the fees questions? Because they're really just, there's really not any explaining on them. Okay, so skip to 20. Which, if any, of the following are true? A writ of habeas corpus may be served on any day. True. 2 says, service of the writ shall be made by delivering the writ. This is a challengeable question because it could be interpreted as incomplete and therefore wrong, or it could be just interpreted as incomplete but still not wrong. So it depends which lawyer you ask.
When you did this question, you should have come up with which of the following answers are correct. The one that's in the answer key, which it says all 4, or one only. One only is complete and correct. 2, 3, and 4, each one of them is somewhat incomplete, but none of them are wrong. what's there is right, but they're all incomplete. So the argument can be made, the best answer is 1 only, or 1, 2, 3, and 4. My view is 1, 2, 3, and 4 is a better answer than 1 only. But as Mary said, very challengeable. But if you came up with something else, you're working with why? Because 2, 3, and 4 are all factually correct but incomplete. The only one that's correct and complete is 1.
So apparently, in lawyer talk, there is a
Obviously-
difference between
Right.
incomplete and still okay, and incomplete and wrong. So when I figure out what it is, I'll let you all know. But anyway, I personally did read that question as an all of the above, but I can definitely see how you could say it's 1 only, because
Yeah.
the others are all incomplete.
And also, the other reason that I did that to make us take time on that question is, the rule about the 72-hour notice is extremely important, and what it exactly says. Because the 72-hour notice question has been on multiple exams in the past. So you really need to know that whole thing about the 72-hour notice. And in what actions, what proceedings it applies to. Okay?
Okay, skip to 21, 7806. Any restitution or damages granted to a petitioner in an Article 78 proceeding must be incidental to the primary relief sought by petitioner. I made this question and I didn't know what it meant, so I'm hoping that someone can tell me.
What is Article 78 about? It's not about money. Okay? Not about money. You can't bring in Article 78 where the objective is pay me money. That's a regular civil action. Article 78 is about what? Arbitrary and capricious. He didn't do what he's supposed to do, or he is doing stuff he shouldn't be doing.
22. True. A judgment debtor served with an information subpoena or a subpoena under 5224 and any other person served with an information subpoena is not entitled to any fee. So basically the banks would be making a killing if they were allowed to charge every time somebody sent them an information subpoena. 7801. The following reliefs obtained previously by certiorari, mandamus, and prohibition are now obtained by commencing in Article 78. And the reason that review is wrong is because the writ for certiorari is the writ to review. So 7802, in the context of an Article 78 proceeding, the terms body or officer includes, and it's everything in that list except for a union. And I think that normally the union would be a petitioner, more likely in an Article 78, than a respondent. 5224, information subpoena served. This is like a really important question, so maybe put a star next. I think it's important. An information subpoena served pursuant to 5224 sub 3 shall contain a certification signed by the judgment creditor, or the statute actually says its attorney, but this says his attorney, stating in sum and substance that to the best of his knowledge, information, and belief, the entity or person receiving the subpoena has relevant information about the debtor. ... Without this document, the subpoena shall be deemed null and void. I'm skipping 26 because it's a repeat of question 11. So question 27, pursuant to 7011, the Attorney General may appeal in the name of the state in any case where the district attorney might do so. Okay, so this one, this next question is kind of relatively new. I think it was around in 2007 they passed it. And this says, in an Article 78 proceeding where a person is detained by order of the family court, ... notice of the proceeding must be given to the judge who made the order. And in such case, the court must be represented by the Attorney General. And when it says the court, they're talking about the family court judge or whatever judge they're talking about. Article 70, the court to which a petition is made pursuant to Article 70 shall issue the writ without delay on any day. 6311, a preliminary injunction may only be granted on notice to the defendant. True. Notice of the motion may be served with the summons or at any time thereafter and prior to judgment. A preliminary injunction to restrain a public officer, board, or municipal corporation of the state from performing a statutory duty may be granted only by the Supreme Court at a term in the department in which the officer or board is located or in which the duty is required to be performed. So now this is one of those ones where if this was incomplete, then it would be a wrong incomplete, because it says only by the Supreme Court at a term in the department, blah, 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 where it's located. So that's why this one needed to have both where the board is located or where duty is required to be performed, because it said only. 6311, notice of a motion for preliminary injunction to restrain a state officer or board, must be on notice to defendant or respondent and must be served upon the Attorney General by delivery of such notice to an Assistant Attorney General. (6314) A party enjoined by a preliminary injunction may move at any time on notice to the plaintiff to vacate or modify it. So for the preliminary injunction, they have the same rules about notice, but the undertaking is a different rule. The undertaking for the defendant is a may, but for the plaintiff, it's a must post an undertaking. 7802, this is just a repeat. Term body or officer includes every court, tribunal, board, corporation, officer, or other persons, or aggregation of persons whose action may be affected by a proceeding under Article 78. This fee question I'm going to read because I think it's, kind of new. In an action to foreclose pursuant to real property actions of proceeding law, Article 13, in addition to the regular index number fee, the clerk shall also collect an additional fee of $190. And then the next two questions just talk about how everything is more expensive in New York City, including certificates. To question 44. So a sheriff is entitled to the current federal IRS mileage reimbursement rate for each mile traveled in performing these services. So the first three are true. The fourth one, I could not find that anywhere in the statute, so I'm going with that's false. And the last one, serving in order of protection, it actually specifically says somewhere that there's no fee allowed for that. Go to question 46, 7501, which, if any, are true concerning the enforcement of a written agreement to submit any controversy to arbitration. So do me a favor, and on number 4, it says the court shall not consider whether. That's supposed to say whether, so please change it on your paper. 1, it may apply to an existing controversy or one thereafter arising. 2, it is enforceable without regard to the justiciable character of the controversy. So that means whether or not that you could even maintain an action in court, the court is not allowed to even pay attention to that. Like, the case could be completely invalid, but the court is not allowed to think about that. 3, it confers jurisdiction on the courts of the state to enforce it. 4, the court shall not consider whether the claim with respect to the arbitration is sought is tenable or otherwise pass upon the merits of this dispute.
Arbitration is greatly favored.
Okay, 7802, which is false concerning arbitration of the CPLR under Article 75. A says a special proceeding is required to bring before the court the first application arising out of an arbitrable controversy which is not made by motion in a pending action. So if you're not already have an action going on and then an issue comes up that can be, you have a contract to say someone has to arbitrate, then you actually have to commence a special proceeding to get the case into arbitration. B, the proceeding shall be brought in the court and county specified in the arbitration agreement. That's true. C, if no county is specified, the proceeding may be brought in a county where the party seeking arbitration resides or is doing business. And then after the arbitration begins, it can be wherever the action is pending, even if you move away. D, the Supreme Court in a county in which an arbitration is pending may, under certain circumstances, entertain an application for an order of attachment or for a preliminary injunction, because the arbitrator can't award either of those things. Okay, so E is false because the time rule is wrong, it's 30 days, but the rest of the sentence is correct. So it should say, if an arbitration is not commenced within 30 days of the granting of provisional relief, the order granting the relief shall expire, be null and void, and costs may be awarded to respondent unless court has reduced or expanded this period for good cause shown. 7505, this is 48, the answer is false because the arbitrator and attorney can issue subpoenas, but only the arbitrator can administer the oath. 49 is also question 6, so we can skip that. Question 50, 7503, which of the following is false? A party may serve upon another party a demand for arbitration or a notice to arbitrate specifying the agreement pursuant to which arbitration is sought. Well, that's true. The name and address of the party serving the notice, that's also true. C, that unless the party applies to stay the arbitration within 20 days after such service, he thereafter shall be precluded from objecting that a valid agreement was not made or not complied with, and from asserting it in court that the claim sought to be arbitrated is barred by limitation of time. D, such notice or demand shall be served in the same manner as a summons. That's the answer because that is the one that's false, because it can also be by registered or certified mail of return receipt requested. Here's another one where it's incomplete but incomplete wrong. 6219. Within 10 days after service upon a garnishee of an order of attachment, or within such shorter time as the court may direct, the garnishee shall serve upon the sheriff a statement specifying. Okay, so this is a little typo in here. Number 1 says all debts, and it's supposed to say all debts that are due to the defendant. So it's all debts due from the garnishee to the defendant. 2, when the debts of the garnishee are due to the defendant, so when they're due. 3, all property in the possession of the garnishee in which the defendant has an interest. 4, the amounts and value of debts and property. 5, if the garnishee has money belonging to or is indebted to the defendant in at least the amount of the attachment, he may limit his statement to that fact. And this was a study question. The answer is all of them. Okay, 7511. Kelly obtains an arbitration award against Anne. Anne participated in the arbitration. Anne is unhappy with the award. In which of the following scenarios could Anne prevail on a timely application to vacate the award? And this is select the best answer, because you can never really predict when someone can prevail on anything. But A says, the court finds that a valid agreement to arbitrate was never made. Now, presumably, you can presume that because Anne participated in the arbitration, she waived the defense, or a court adjudicated that there was a valid agreement to be made. B, the court finds that Anne's rights were prejudiced by a fraud perpetrated by Kelly in order to obtain the award. So even if you didn't know the answer to this question, this would be the best guess, right? Because it says fraud, and whenever there's fraud, the courts don't like that. C, the court finds that Anne's rights were prejudiced by partiality of an arbitrator who was appointed by a neutral, and the award was by confession. So this would have been true if the award was not by confession. D, the court finds that the agreement to arbitrate was not complied with. And again, this was waived because if you participate in the arbitration, you waive it if you don't challenge the agreement. And if you do challenge the agreement and a judge says what was complied with, that would result in you participating in arbitration. So the answer to this one was B. 7514. The judgment rule in an arbitration proceeding consists of 6 things. It's 1, the original copy of the agreement. 2, each written extension of time within which to make an award. 3, the statement required by 7508 when the award was by confession. 4, each paper submitted to the court and each order of the court upon an application under 7510 and 7511. And then number 5 is the one that's wrong. You don't need the minutes of the proceeding unless the court, I guess, wanted them. 6, a copy of the judgment, obviously you need that. And 7, you need the award. Okay, so 54, this is a long one. It's a long read. The reason that 4 is wrong is because the action would have to be based upon a conviction. So this is a tricky question because it's very, very wordy, but the key here is that it can't just be a charge crime. It actually has to be a conviction in order to get this order of attachment under these circumstances. So if you're talking about something with the executive law, it has to be a conviction. So the answer was everything except for 4, and the rest of it, so if you want to change the word charged into after a conviction, so the action is based upon a conviction, then you could have a study question there because the rest of them are correct. Question 55, the answer key is incorrect. I apologize for that. This is 6211, and it says an order of attachment may be granted without notice before or after service of the summons and at any time prior to judgment, or is provided in 6205, ... and such order shall specify the amount to be secured. Because B says the name and address of defendant's attorney, and it's actually the name and address of plaintiff's attorney. C says the date of the judgment. Well, in the question, it gave it away that it has to be at any time prior to judgment. 56, 6211. Except for an order granted on the ground specified in 6201, which is the non-domiciliary or foreign corporation, an order of attachment granted without notice shall provide that within a period of not to exceed 5 days after levy, the plaintiff shall move by order to show cause for an order confirming the order of attachment. 6211, except for an order of attachment granted on the ground specified in 6201, an order of attachment without notice shall provide that within a period of ... I didn't want to give it away because it was in the last question. The plaintiff shall move on such notice as court shall direct to defendant, sheriff, and garnishee, if any, for an order confirming the order of attachment. And 7511 is the grounds on when you can vacate the award, I think, so that's why Frank wants you to read that carefully.
It was easy as pie.
No.
Wasn't it?